You'll give us what we want, or we'll make sure you never see the house again. That was Grandma Edith's voice, calm, icy, like she was negotiating a lease, not threatening her own grandchild. She folded her hands over the mahogany table and smiled the way people smile before they stab. By Christmas, we'll be living rent-free and you'll be the one begging us for crumbs. Have you ever had the people who raised you act like strangers with invoices? I remember sitting across from them in the cramped dining room of their Seattle bungalow, sunlight pooling on their 80s wallpaper, and feeling something inside me crack. They weren't asking for help, they were billing me. They wanted $3,200 a month, cash only, for caretaking and legacy expenses. My phone buzzed with a text from Grandpa Harold. Don't be dramatic. You know how family works. You owe us. He sent a picture of the old deed to the house and a scan of a faded birth certificate, like that everywhere ominous smile you'd see in a scam email. I was 32, newly divorced, barely holding down a freelance contract, and a battered Tesla I couldn't afford to insure properly. I had been living with Edith and Harold since my parents died, because what else do you do when your only family is toxic but somehow indispensable? But this was different. This wasn't the tight belt we all understand after a loss. This was extortion wrapped in knitted sweaters. I'm going to take you for everything you've got, Edith said, leaning forward. You're too stubborn to see what's coming. You should have signed when we asked. Signed what? I asked. You're asking for cash, not a confession. Don't play stupid, Harold cut in, his voice low. We kept this family together so long. The house should stay in the family. And if you won't do what's right, we'll go to probate. We have rights. Little did I know, they actually thought they had rights. They were wrong. But I had no idea what I was about to discover. Have you ever trusted people so deeply that the idea they would betray you felt insane? Tell me in the comments, would you have left? Would you have paid? What followed was months of manipulation, late-night guilt texts, passive-aggressive notes about family obligations. Threats thinly veiled as concern. You don't understand responsibility, Edith would say. People like us don't live forever. They started to show up unannounced during interviews, linger in the driveway until I got home from client meetings. I found a Ring doorbell clip that captured Edith rifling through my mail. They would bring up the estate at family dinners like it was a pie to be split mid-conversation. If anyone's been through a messy divorce, you know that feeling. The small, constant erosion of boundaries. Anyone who's been forced to move home knows the humiliation. But I wasn't helpless. I kept receipts. I took screenshots. I saved every text, 47 deleted messages that later surfaced in the iCloud backup. I recorded long voicemail. Rants from Harold demanding loans that would never be repaid. I saved bank transfer confirmations, $8,000 here, $1,200 there, money they said they'd use for special expenses. I put my Ring footage in a folder I labeled evidence, and I backed it up twice. And yet, there were hints I missed. A photocopy of a legal-looking document they left on the dining room counter, half obscured under a crossword puzzle. Edith muttering to herself, "We did the smart thing back in '85. I tucked it away, thinking of course they had done something. Their generation did things differently. But that line, back in '85, wouldn't leave me. But I had no idea the real bombshell was tucked into a paper file from 1985 that until a week later lived only in a dusty county records office. You won't believe what I found next. I called my friend Mia. She's blunt, works as an accountant, and had that look people get when they smell fraud. "Dude," she said, scrolling through the messages I forwarded. "This isn't family obligation. This is predatory. You need a lawyer." So I did something I should have done months earlier. I called a lawyer. Margaret Chen, small firm, big cred. When she met me at a coffee shop in downtown Bellevue, she didn't ask for my life story. She asked me one question. "Do you have proof?" I slid my phone across the table. She tapped through the texts, cues, and bank screenshots. Her mouth thinned. "We can work with this," she said. "But it's not just the texts. You need a document trail." Margaret started digging. She filed a public records request for the property, ordering a full title report on the bungalow in Seattle where Edith and Harold lived. She pulled probate filings, wills, and every document with the family name. We pored over them in her office. Burgundy leather chairs, legal pads, and a wall of framed diplomas. There were a few puzzles. The house deed, for example, was still in Edith and Harold's names. The couple had been listing it as collateral in veiled threats. Yet there was also a yellowed file from 1985 labeled custodial renunciation. It was the kind of phrase you only see in a history book legal drama. When Margaret read line 3 aloud, I felt cold. Edith May Caldwell and Harold James Caldwell do hereby permanently and irrevocably renounce, relinquish, and waive all parental and custodial rights to their grandson, effective June 12, 1985. Signed, notarized, county stamp, 1985. 39 years ago. I remember thinking, so what? That was 39 years ago. But Margaret wasn't done. This is not about custody, she said. This could be about legal standing, to act as fiduciaries, to claim certain entitlements, to be named as executors. It could invalidate their current claims. Hold on. What does a decades-old renunciation mean? Would it stop them from demanding money now? We started to peel back lids on things I didn't even know were sealed. We subpoenaed old probate records. We found a 1985 agreement between my late mother and Edith and Harold. She had been fighting addiction. The grandparents agreed to take custody for a while. But in the end, she reclaimed legal custody. And Edith and Harold signed a formal renunciation to remove any question of parental rights. It meant they had given up custody and, crucially, any future claims as legal guardians. They had agreed not to be legal decision-makers for the child they were raising. But here's the twist. When my parents both died, the estate paperwork was messy. There was no clear will naming beneficiaries for household items. And Edith and Harold started to argue that, as longtime caretakers, they'd earned a stake. They began to conflate moral care with legal entitlement. We found more. 47 deleted messages on Edith's phone, messages that had been auto-backed up and then removed. They were from a number labeled lawyer and included lines like, "We can pressure him on conservatorship. If we start now, he won't fight. Make him sign. Use the mortgage. We already have the deed. We just need him to agree." And then one message that stopped my breath. "Remember 1985? That paperwork's a blessing. Use it. Claim you've been doing his care since then. Spin it into rights." Wait, if they had renounced rights in 1985, why would they tell each other to use it? Because they planned to lie. What happened next felt like a scene out of a legal drama. Margaret pulled a chain of emails from a private attorney the grandparents had consulted last year, a man named Robert Hale. He'd sent an estimate for probate initiation and conservatorship strategy. He'd even drafted a fake affidavit of caregiving that mirrored the formatting of old county forms. Robert charged them $9,500. They paid with cash. I felt a rage so hot it blurred vision. This was betrayal on the scale of identity theft, family identity theft. They'd been billing me as if I were their tenant. They had been siphoning funds, and they were planning to forge the past into legal leverage. Could I stop it? Would the court see through the lies? That was when things got messy. Margaret napped our plan like a chess player explaining a checkmate. First, we needed to show the court the 1985 renunciation, public record, notarized, stamped. Second, we needed to prove that any current claims by the grandparents were based on manufactured documents. Third, we needed to show a financial trail, bank records, cash deposits into Grandpa's account, and the $8,000 wire labeled gift that had been used to pay Robert Hale. We subpoenaed bank records, recovered the deleted iPhone messages through a forensics firm, and hired a handwriting analyst to compare a suspicious affidavit with known samples of Edith's signature. There were moments when the plan wobbled. 3 times it almost collapsed. Moment 1. The forensics firm called 2 days before a court hearing and said the iCloud backup had been partially corrupted. We recovered about 60%, the text said. My heart sank. Without those messages showing the grandparents' plan, we were left with motives, not proof. Moment 2. Edith's lawyer, an aggressive woman with a gold watch named Marlene, served us with surprise discovery. She produced what looked like an estate ledger showing the grandparents had paid for certain maintenance expenses for the house since 2009. It was formatted to look like a ledger from the county, and it had been notarized. If it passed, it would lend legitimacy to their claims that they had been caretaking all these years in a way that entitled them to reimbursement and perhaps a lien. Moment 3. A family friend who had been on our side suddenly sent a text that seemed to back the grandparents up. "I always thought you were the problem," he wrote. "They did so much for you. Maybe you should be grateful." That cut. I almost blinked. But then, two things happened almost at once. We recovered more of the deleted messages, 47 total. The forensics team worked nights and recovered metadata that tied the lawyer contact to a local bar where Robert Hale had left a business card. A card that linked to a P.O. box and a P.O. box that matched a mailing receipt for the fake affidavit. The handwriting analyst called and said, "This is not Edith. The pressure consistent with the signature doesn't match." This was traced to a different pen and style. Marlene's notarized ledger? The county clerk called and said the ledger file had never been filed in the county's official records, meaning the notarization was likely a fraud done by Robert Hale or someone he cooperated with. Suddenly, the move that had seemed impossible began to look possible. But then, just when momentum swung our way, the grandparents hired a private investigator and found out where Margaret had her client meetings. They started showing up outside her office, staring in through the window. Edith left one of those old-school handwritten notes under my windshield wiper. "We own you," signed Edith. She also started a rumor campaign among family friends, whispering that I was a money grubber, that I had kicked them out, and was using the house as my own. What would you do if the people who raised you started painting you as the villain? Would you fight back in public? Would you pay to make the noise stop? I kept asking myself that every day. The court date arrived in a gray Seattle courtroom with high windows. I sat with Margaret and watched my grandparents settle into the gallery like jurors of their own fate, calm, like they were preparing to be vindicated. Marlene sat across from Margaret, wrists heavy with bracelets, confidence radiating. The judge, a stocky man named Judge Rivera, had a face like a ledger, no expression but a lot of accounting. He opened the hearing. "This is the matter of Caldwell versus Caldwell. Preliminary petition. Counsel, we will begin with the motion to determine entitlement." Marlene spoke first, voice polished. "Your Honor, my clients, Edith and Harold Caldwell, have been the primary caretakers of the petitioner since childhood. They seek reimbursement and the court's acknowledgement that their role entitles them to a lien against the estate pending probate. We present an affidavit of caregiving, notarized, and receipts." Margaret smiled in that way lawyers do when they start a good cross. They were baiting a trap. "Your Honor," she said, "we have evidence showing that the affidavit offered by the respondents is likely forged. We have a public record from June 1985, wherein Edith and Harold Caldwell signed a renunciation of parental and custodial rights. That renunciation strips them of the very fiduciary standing they currently claim to create a conservatorship or lien tied to caregiving." Marlene's mouth went tight. "Irrelevant," she snapped. "That was a different time. Circumstances change." "Not if it's signed and notarized," Margaret replied. "We also have recovered 47 deleted messages that directly show a plan to manufacture documents to claim entitlement. Those messages are time-stamped and originate from a phone used by the respondents. We have bank records showing payments to an attorney, Mr. Hale, for drafting those documents, and a handwriting analysis verifying the affidavit they submitted was not authored by my clients." There was a silence like a held exhale. Edith's eyes darted to Harold. Harold's face blanched. Edith stood up before the judge could respond, and these words, these exact words, left her lips. "You're too stupid to even see what's coming. You always think people are against you. We did what we had to do. You're going to take me for everything you've got, she said, as if rehearsing a line she'd already said to me in the dining room. I deserve this house. I raised him. Raised him, Harold echoed, softer. He was ours once. He belongs to us. Margaret said, Sir, people don't belong to others in this courtroom. We have lawful documents. She slid out the yellowed 1985 record and placed it on the bench, watching the judge's eyes pass over the county stamp, the notary seal, the signature. The judge read, Mrs. Caldwell, he said slowly, this renunciation would mean that as of 1985, the respondents legally relinquished rights of parental custody. If true, it undermines any claim that they are compelled to serve as fiduciaries now. He looked at the paper. What's your response to the authenticity of this document? Marlene sputtered for a second, then pivoted. Your Honor, records can be mistaken. We can test the scope. My clients acted as de facto caregivers. We should be allowed to pursue equitable relief. Margaret had another card. She motioned, and the recovered metadata printouts were admitted. The courtroom watched a timeline. Texts, the $9,500 payment to Robert Hale, the P.O. Box mailing receipt, the handwriting analyst's report. When the judge read the line, noting the forged notarization and the connection to an outside attorney, Edith's shoulders shook. The look on Harold's face as he realized the ledger and affidavit were not going to hold, like someone pulling coins from a magician's sleeve. Then, in a twist I didn't expect, Edith tried to blame everything on Harold. He did it, she cried. It was his idea. He took the money. I didn't know about the forgeries. Harold's reply was venomous. Don't you gaslight me now in front of the court. We agreed. We both signed. Then came the worst moment for them, and the best for me. The judge asked their attorney if they had ever in writing attempted to establish conservatorship or filed for guardianship since 1985. Marlene shifted. She admitted there were no filings until the recent one. The judge looked at me. Mr. Caldwell, he said, do you want to make a statement? I stood. For a second, I was that kid again, small, hands fidgeting. But the months of evidence felt like armor. Your Honor, I said, they didn't care for me out of love. They cared about controlling the house and the money. They'd been taking my money for years and trying to engineer a legal route to take everything. I have the messages. I have the receipts. I have the document from 1985 proving they renounced any legal claim in the first place. Edith's face crumpled, then hardened. You don't understand loyalty, she shouted. We held this family together. Judge Rivera's gavel tapped. Given the submitted evidence, he said, this court finds probable cause to believe that the affidavit submitted by the respondents was not authentic and may have been fabricated. Further, the renunciation in 1985 appears valid on its face and undermines the respondent's claim to fiduciary standing. The motion for interim lien is denied. Counsel for the petitioner is instructed to file for a full forensic accounting of transfers from the petitioner to the respondents over the last 15 years. It felt like someone had turned on the lights. Edith's shoulders sank, and Harold's mouth opened like he'd been punched. They whispered to each other, a small, ugly conversation the judge cut off by clearing his throat. The courtroom dispersed, and for the first time in months, I felt something like breathing. But the story didn't end there. There had to be punishment. The judge ordered an investigation into the alleged forgery and an audit of all financial transfers. Margaret filed a civil suit for embezzlement and for the return of funds, and the county prosecutor opened a criminal investigation into the affidavit's notarization and Robert Hale's role. The next twist? Robert Hale had a record. He'd been disciplined 5 years earlier for fraudulent notarizations. The prosecutor found his involvement and charged him. Marlene, the grandparents' lawyer, withdrew after an ethics probe discovered she had not forwarded all discovery in good faith. Edith and Harold were named in a civil suit, and a restraining order was issued preventing them from contacting me directly or approaching my place of work. Within 3 months, the bank froze 2 accounts, one with $62,400 in cash deposits over 5 years, marked as gifts. and another that showed a pattern of small monthly transfers that matched the $3,200 demands. The forensic accountants traced $37,200 directly back to the grandparents' joint account, money that, by the court's logic, was taken under false pretenses. The judge ordered restitution. Do you know how it feels to watch justice be counted in dollars? Mixed, satisfying, but also hollow. 6 months later, the publicity had done its work. Local news ran a short segment. Toxic caretakers lose case after forged documents, prosecutor says. Photos of Edith and Harold on their stoop circulated with comments I couldn't help but read. Some were cruel. Serves them right. Others were kinder. Survivors of elder abuse deserve protection too. I thought of the nuance. How do you differentiate between an elderly person in need and someone who weaponizes need to bleed you dry? What about the house? The legal team forced a settlement. The grandparents signed a binding agreement relinquishing any claim to the bungalow and agreeing to repay $37,200 in installments taken from their accounts, plus $8,500 to cover legal fees. They were also barred from ever contacting me and from initiating any probate action related to my parents' estate. In essence, the 1985 document had done more than protect me. It exposed their scheme. I won't lie. Some people told me I went too far. Why push for criminal charges? A cousin asked. Why not just cut them off? Why make their last years miserable? But here's the thing. When someone weaponizes family, it's not just personal. It becomes a precedent. If you let it slide, you're building a manual for the next person. Was I wrong to pursue justice? Maybe in the way that justice often hurts. But I couldn't let them turn years of manipulation into legal ownership. After the dust settled, I did something small and human. I invited a few friends over, cooked a terrible lasagna, and sat on the porch without flinching when I heard the creak of the gate. I let myself sleep through the night without checking the door. I started to rebuild credit, slowly. I started dating Sarah, a patent attorney I'd met through Margaret, who texted me a GIF the first week and a half after the trial that said, "You did good, stranger." She laughed at my Tesla jokes and didn't flinch when I mentioned my grandparents. People are complicated, she said. Some of them are villains. You're not defined by other people's greed. What's the life lesson here? Boundaries are legal and emotional. Documents from 1985 saved me, yes, but it was the small acts, saving texts, backing up ring footage, hiring the right people, that turned a dusty piece of paper into a weapon against extortion. The world is full of gray rooms with legalese. Sometimes justice is finding the right light switch. Tell me, if you were in my shoes, would you have done the same? Would you have gone public? Would you have accepted a quiet cutoff? Drop your answer in the comments. Tell me I'm not crazy for demanding restitution. Was I wrong to let the prosecutors in? What would you have done differently? I kept the screenshots. I kept the court papers. I uploaded the ring clips to the cloud with 3 backups. I made a binder titled Never Again. I put the 1985 renunciation in a frame on my bookshelf, not as a trophy, but as a reminder that people sometimes sign away their rights, and sometimes those signatures come back to save you. There are still echoes of those days. Sometimes, when mail hits the mat, I half expect a napkin with a note from Edith demanding lunch money. Sometimes, a mutual family friend will send a tentative text, and I'll respond within the boundaries I set. Short, factual, non-emotional. I prefer not to discuss, I'll write. They are human, frail, and stubborn, and they made conscious choices. A few months after everything wrapped, I walked past their bungalow in Seattle. They'd sold it, quietly, and moved into a small assisted living place in Bellevue. I didn't go speak to them. I didn't need to. Justice isn't always about seeing the other person crumble. Sometimes it's about walking away with your hands clean. When I passed, a neighbor shouted, "Hey, you did good." I nodded and kept walking. One last statistic to leave you with. 47 deleted messages, 39 years since the renunciation, $37,200 returned. Those numbers are particular, and they'll haunt me in different ways. Not because of the math, but because they map a trail of what people can do when they choose manipulation over love. If you want the receipts, yes, I have the screenshots. Yes, the court documents are public record. You can look them up if you want the full docket. But what I really want to know is this. Have you ever had a family member turn legal strategy into emotional blackmail? What did you do? Would you have pressed criminal charges? Would you have settled quietly? Leave your story in the comments. Some people say I went too far. Others told me I saved myself. Was it revenge? Maybe a little. Was it justice? Ultimately, yes. If you were in my shoes, what would you have done? Drop your answer in the comments. And if you want more stories where justice bites back, raw courtroom drama with a twist, subscribe and hit the bell. I've got dozens more like this one.